Good afternoon and welcome to the third in a series of webinars that we have been doing as the Task Force on Alternative, Informal and Other Means of Accessing Justice, which we commonly call the Ajs Task Force. We have been having these webinars to build critical support of various actors in implementing of Ajs, and even as we have a run-up towards the launch of the policy on 27th of August. Today, we have a webinar that is themed civil society organizations and their role in implementing Ajs through their areas of practice, research, and community outreach. So far, we have engaged the academia, and we have also engaged the gender justice, and we are excited that you are here with us today, and we look forward to your engagement. My name is Teresa Mutua of ICJ Kenya, and I will be your moderator today. To help us understand the journey of the task force, its findings and recommendations, I am joined by a team of experts and colleagues who are passionate about Ajs. I am joined here in studio by Timothy Mwishigi of the Legal Resources Foundation, and he is a member of the task force. Welcome, Tim.
Thank you very much.
I'm also joined online by Commissioner Jedida Warohio. She is a task force member as well. Karibu Jedida.
Asante sana, thank you.
I am joined by Dr. Steve Akoth Ouma, who is our vice chair of the task force. Karibu sana, Dr. Akoth.
Asante sana.
Great. We will also be joined by Gertrude Angote of the UNDP, who will join us later on in the session. So why is Ajs important for us as civil society organizations? Whether we are working in the justice reform sector, and therefore access to justice and dispute resolution becomes central to our work, or we have the mandate of promoting human development and democratic governance, or even that our mandate revolves around poverty and conflict resolution, Ajs is important to us. We have Justice Sitati to tell us a little bit more about why Ajs is important. Welcome.
The alternative justice system is one where the parties themselves choose or are encouraged to participate in it so that they can have their matters resolved quickly as opposed to the court system. If more cases, the smaller cases or even the bigger cases go to Ajs, that means removing them from the courts, and that means that we are reducing the backlog. And secondly, we believe, even as judges, that a judgment that has been agreed between the parties is a much better judgment than the one that I write. The law may be clear, but you see, when these parties agree between themselves, each one goes away satisfied. But when a judge passes the judgment, the one who loses will always feel, maybe I should have won, or something like that. So in that one, the status is equal. Each side feels good because they have participated and they have agreed.
Indeed. And a research by the UNDP shows that globally, about 80 to 90% of societal disputes are resolved outside the court system, just like Judge Sitati was saying. And in Kenya, the Judiciary Training Institute, in partnership with the Hague Institute of Innovation of Law, commonly known as HIL, conducted a justice needs and satisfaction survey that revealed that out of 60% of Kenyans who find that they have situations that require resolving in a judicial system, out of those, up to 90% of the Kenyans resolve these situations or these disputes outside of the formal court system. Now that tells us something as civil society organizations, that we need to pay attention. The Constitution of Kenya guarantees us in Article 48 the right to access justice. It also, and in the Constitution, gives judicial authority that is derived from the people, but vested in the judiciary and to be exercised by the judiciary. A key principle in exercising judicial authority, to which the task force has derived its mandate in Article 159(2)(c), says that this principle, the judiciary should promote alternative forms of dispute resolution, which include reconciliation, mediation, arbitration, and traditional dispute resolution mechanisms. Now, as a task force, we know that AJS is not a panacea, apologies. It has gaps and it has challenges, just as it has benefits. So today, the panelists we have will take us through this topic. They will tell us what are the advantages. They will tell us what challenges we have encountered as the AJS task force, how we came up with the policy, and we will also interact with you, our participants, through the question and answer session. So kindly, we encourage you to send your questions. You are free to direct your questions to any of our panelists, and towards the end of our session, we will be careful to interact with you. I am already pleased to say that we already have participants who are interacting with us. Ahmed Said, I see you. Stephen Oguna, I see you. Yusuf, we see you. Everybody saying hello to the task force and hello to the participants. Continue to bring in your questions and we will address them towards the end. But to begin us off, and with Commissioner Jedida, as a task force member, kindly take us through who we are as a task force, our mandate, and how it is we came to the work that we are doing. What are the constitutional considerations that we undertook towards the journey, and especially through our research phase? Over to you, Jedida.
Thank you very much, Teresa, for that introduction. As a member of the task force, I'll take you through what our mandate was. The task force was known as the Task Force on Traditional, Informal, and Other Mechanisms Used in Alternative Justice Systems, popularly known as AJS. The task force was gazetted on 29 February 2016 and later extended until 2018. However, the task force continued to work and to do its work for the last 2 years to ensure that we were able to get a feel of what Kenyans wanted in terms of the AJS. I will use the word AJS most of the time to describe the systems, and more so to call it, instead of alternative, to really call it the appropriate justice system. So what was our mandate? Our mandate was to consider and to formulate an appropriate AJS policy that would guide the judiciary, because the judiciary has the authority to manage AJS systems in this country. And this is the first important mandate that the judiciary was given. And two, the other aspect of the mandate was to look for concrete and practical ways to mainstream AJS within the judiciary so that it can assist in case backlog and also assist in the administration of justice. And we've heard that from Justice Sitati. The third mandate was to propose a national model that could be annexed or would be annexed with the judiciary so that it could become the AJS court annexed model. And finally, it was to ensure that the AJS policy did not remain on paper, but we developed a strategic plan to ensure that it became operational immediately the policy was formulated. So to undertake our mandate, we had the task on convening various stakeholders AJS practitioners, civil society, human rights defenders, paralegals, to explore and to appreciate how the AJS was working in their respective communities. So we mapped out a number of AJS systems and mechanisms, and also studied to see how that linked up with the judicial system, and also evaluated and looked at issues of how they were complying with the constitutional national values and principles. We undertook a lot of desk review, and this dialogue today in this webinar is very important because a lot of the work on AJS has really been done by civil society, and we read a lot of the reports, the manuals, the guiding notes that have been developed over time by civil society, and also looked at the anchoring legislation that would assist in mainstreaming AJS. We worked very closely with the Judicial Training Institute, indeed it's our secretariat, so that we could be able to pilot some of the models we were thinking, especially the court annex model, and also benchmark existing court annexed models. And we had a number of them that we looked at so that we could observe and learn and document. So through this process, we documented a lot of good practices. We documented the impact, both the positive and the negative impact AJS systems had. We also documented the challenges, which we're going to be sharing, and the good things that took place in the communities. The last thing, and this is also why we're having these webinars, was to begin validating and seeing and testing the various models that we have documented as the task force, and also the policy proposals with various stakeholders. To undertake this work, we were guided by a number of questions, key questions, to help us have a standard template in all AJS mechanisms. And these standard questions are also linked to the strategic plan for operationalization. And for the first strategic objective was to look and identify the nature of cases and the constitutional compliance of these institutions. So we asked the AJS practitioners how people access the AJS systems, the nature of cases, or the type of cases that the AJS mechanisms engaged in, and if they were criminal in nature, how did they handle this vis-a-vis the role of the Office of the Director of Public Prosecution. We also had sessions where we brought to their attention their compliance or lack of compliance with the Constitution and the other human rights principles, and had them help us appreciate how they specifically protected, especially the vulnerable and minority members of the community. We also had the questions around identifying cultural practices or traditional practices that were considered harmful to the community, and how the AJS systems practice this. The second objective was to see how to strengthen how we would strengthen the AJS mechanisms, and understand how they appointed the members, either by election or selection, how they made their decisions, and how even the removal went about. And so we had specific questions about telling us, how do you appoint the elders or the council? How do you include the minorities within the leadership of the decision-making bodies? If it was a mixed community, how did you include the minority ethnic groups within the decision-making process? The whole issue about the marginalized and the vulnerable was very, very critical. Were women part of the leadership? How did the youth participate in the decision-making? And also, what linkage and what role did the national government, the chiefs, the police, the county administration play in the administration of this? And those also assisted us to identify the capacity needs of each institution. The third issue was about how to develop procedural standards, and also to develop for the first time very positively and proactively customary law jurisprudence in this country. So we wanted to know the minimal requirements of accessing AJS and what standards were in place. And we were also very alive to the fact of the history of this country, where customary law is secondary to common law, and wanted to see how the customary practices within the various AJS, those that were using it in their classical sense or in the mixed sense, how that was evolving and how they were documenting it and ensuring that it remained relevant to the situation of the day. The fourth objective was to look now at the end of the AJS session. Decisions were made. What sort of decisions were made? Who were the interlocutors or intermediaries in those sessions? For example, would want to find out, were lawyers, did they use lawyers, or do they use paralegals, or how would these act as the intermediaries and support the AJS mechanism? In their decisions, what remedies did they put in place in terms of, because the AJS, you will not find a situation where someone is sent to prison. So what sort of remedies did they have to resolve the situation? What sort of punishments did they give? What sort of sanctions did they provide? And when, after making the decision, it was very important for us to appreciate, were these decisions followed through? Was there compliance? And if there was no compliance, how did they go about it? And if there was external assistance in terms of compliance, who was that and how did that come into play? The last strategic objective was really to think about the whole issue of sustainability and resource mobilization. Because these mechanisms have been in existence for a long time, even before we were born. They're really part of human evolution. So we needed to know how they have been facilitating the AJS, either logistically, administratively, financially, and how this would look like in the future. We were specifically interested because we noticed there was a major involvement and interaction with the Ministry of Interior and Coordination of National Government, how that played out, what role they would play, what role would the police play in the administration of justice in AJS, among other things, so that then we were able to propose and have some issues in terms of how we were to sustain the AJS and how the resources would be mobilized. A question that was very general and was very important is and appreciating the challenges of these AJS systems within their own environment, and also vis-a-vis the judiciary, and also how AJS worked in mixed societies. And this was particularly important, especially in the urban centers, in formal settlement areas, because we do not have we do not have one classical group of societies. It's really mixed and evolving. So finally, the task force had to be guided, as Teresa has said, by the constitutional obligations that are there, because this is the first time in the Republic of this country, on behalf of the judiciary, that the judiciary is actually interrogating the place and the role of the AJS mechanisms and systems within the judicial function, within the judicial authority, within the justice arena. And therefore, some of the constitutional obligations that we were guided and ensured that we also had an opportunity to share, to train, and to capacity build the AJS systems as we went along, was one, that we needed to ensure that we promoted the sovereign power of the people, which they have a role and a responsibility to exercise either directly or indirectly. Two, the task force and made it very clear that this was a judicial obligation, and it was their role to ensure under Article 159 that the people of Kenya were able to utilize this system. We were also guided by the fact that in our constitution, Article 11 and 14, the right to culture is a right that comes alive when you're thinking about AJS. Issues of enhancing access to justice as a critical parameter that ensures that AJS delivers justice in an expeditious way, in a most fair way, without discriminating, was also another parameter that was guiding the task force. An important parameter was the whole issue of protecting and respecting dignity, so that we had to look at the AJS system vis-a-vis how did they dignify each and every member of society, including those who are least or most vulnerable or poor in the community. Also, the whole issue of using a human rights-based approach in ensuring that we promoted human rights and protected human rights. We were guided by three critical aspects. One is to ensure that, there was need for AJS to respect and respect human rights and freedoms, where the individual becomes then very central in the promotion and the protection of the Constitution, because they will be able to generate the knowledge, they will be able to ensure that they are not, they monitor the impact of AJS, and the judiciary has the obligation to protect the existence and the promotion of AJS systems. Two, the whole issue of protection. The state needs to uphold and protect AJS mechanisms, particularly because the right holders need to be protected from any violation. And the state organs have a singular responsibility to ensure that human rights are protected and promoted, and the special categories, especially the vulnerable, the marginalized, and the minorities are protected. And lastly, from a rights perspective, the whole issue of transformation. AJS mechanism is really a great opportunity for us to transform our justice arena, our justice infrastructure, so that we're able to promote and facilitate the rights in terms of access, in terms of remedies, and in terms of the whole process of accessing justice in this country. Finally, the last constitutional obligation has to do with the Constitution is very clear in terms of disputes that are of a traditional nature, disputes that are of community groups, and disputes that are of community land need to be resolved through an appropriate system. And the AJS is one of those mechanisms that is identified in the Constitution. So again, how were these justice systems living up to the constitutional obligation? So in a nutshell, that was really what the task force was mandated to do, and to ensure that it listened very keenly and captured the aspirations of the AJS practitioners, the AJS users, and ensured that all this was captured in a policy on AJS and models that then would work in any given society, not a cut and paste mechanism on AJS. So thank you very much. Thank you very much.
Great. Thank you very much, Commissioner. Thank you very much, Commissioner Jedida. I'd like to recognize our participants who are tuning in from various counties, various parts of this country, from Mandera to Nakuru, to here in Nairobi, to Kericho, to Kwale. We see you, Commissioner Masideche, we see you. Good afternoon to you too. Continue to send in your comments and your questions in the question and answer, and we will get an opportunity towards the end of our session to address these questions. You can also just direct your questions to the panelist of choice, and we will give them an opportunity to answer you. Now, if you're joining us, what we have done with Commissioner Jedida is she has taken us through a journey of what the Task Force on Alternative Justice Systems went through. She's told us the mandate that the Task Force has. She has given us the areas that we went out, and she has mentioned that we did pilot projects. She has also given us a few questions and the objectives for these questions to show us what did the task force want to find out. What did we go out as a task force to see? What did we set out to observe? And coming in to now tell us what the findings of the task force are, and what therefore went into the policy that we have developed, is none other than our Vice Chair, Dr. Steve Akoth. He's going to share with us snippets of the Kenya policy, the policy on AJS, the provisions. which come from our understanding of the challenges that we met, the findings that we saw as a task force, and what the AJS history, the history as we understood it from the various settings that we studied. So over to you, Dr. Akoth.
Thank you very much, Teresa, and thank you very much, Commissioner Jadida, for the presentation. I must say that I'm actually quite excited that after those many years of work, our work seems to be bigger than ourselves. So allow me to start from behind. I saw some people asking for the presentations. We are going to, the Chief Justice is going to be launching the policy on Katiba Day, the 27th of August this year. And on that day, he will also unveil the popular version of the policy, which has all the contents of these presentations. And that will be available from that day. The task force is also putting together a website. All the materials will be available on the website. So through the chair, Madam Teresa, it will be important that you take note of our email address, and we would like to encourage every one of us to be part of the launch on the 27th. And you can send your details and stuff through that email address, which the chair of this session will keep flagging up. Finally, before I go into my presentation, I also want to register the apologies of the chair to the task force, Judge Professor Joel Ngugi, who is in another meeting of a similar nature at this time, and so couldn't join us in this session, but I think he will log in at the tail end of this discussion. So back to the mandate that I've been asked to execute, I want to start from where Commissioner Jadida left. The Constitution is a beacon of this work, and the work on alternative justice systems is based on our appreciation and what we want to do with diversity as a country. The Constitution, the preamble, declares our pride in ethnic, cultural, religious diversity, and our determination to live in peace and unity as one indivisible and sovereign nation. That's a very important component because AJS is based on the principle of legal, cultural, social pluralism. So this plural framework is one that the Constitution also appreciates from the beginning. And in appreciating that, we also want to borrow a bit the work from the Aga Khan, who has argued that the world we seek is not one where differences is erased. So AJS is one of those initiatives that pursues differences as an asset, but where differences can be a powerful force for good. And we think AJS is a powerful force for good. The good here is access to justice and promotion, and preservation of human dignity. And also can fashion a new sense of cooperation and coherence in our world. And here, the policy we have suggested suggests frameworks for creating cooperation between the judiciary and various non-state actors, and also create coherence in our endeavors to pursue access to justice. In terms of in terms of our history, and I thank very much the member of the task force, Madam Jane, who drew this diagram. Our history is based on this multiple contribution to justice. That justice is contributed to by families and individuals, traditions, religion, peace committee, courts, mediators, administrators, arbitrators, and community. So we all go into the pool of justice. So we know as a task force that even the name AJS that we use at the moment may in the future be a name that will be renegotiated so that we talk more of multiple avenues of delivering and accessing justice. This is represented in terms of our history and rationale of work by this river, we call it river of justice. And here you get the idea that there are many disputes that occur in everyday life, but look at the number of disputes that gets to be resolved by the courts. And so for a constitutional establishment like Kenya, it becomes imperative to think through how do we make sure that the dispute resolutions and justice systems that operate between here and at this age are done in tandem with the provisions of the Constitution. This is really what grounds, and this is a rationale of our work, and the statistics about this were raised at the beginning of the conversation by Madam Chair of the session.
Dr. Steve.
Yes?
Dr. Steve, please, can you share the river of justice? Because we are not seeing. Please share it for the members.
Can you see it now?
No, I think share your screen.
Okay, sorry, there must have been a problem there. I'm sorry.
Dr. Steve, you can, on your screen, you can just click the share screen.
Is it okay now?
Yes,
Is it okay now?
Yes.
Okay, we can go ahead.
What happened was I think the system hung at some point. My apologies. So indeed, we have the river of justice here, which sort of represents the history and the rationale to this work. And the idea is that there are many disputes that take place, and there are very few that get resolved in the court. The work of the task force, as explained by Commissioner Jadida, was about designing a method of collaboration and action that is consistent with the provision of the Constitution of the work that takes place between here and here. Some of our findings. First, the keywords. The first keyword is, what is AJS? I know that Article 159(2)(c) talks about traditional dispute resolution. But as you heard from the question that we dealt with initially, the drafters of the Constitution in talking about traditional didn't just mean anthropological tradition, that is those that are based on ethnicity, based on religion, or based on creed and so on. But they also looked at other traditions that emerge out of continuity, such as what we see in the informal practices, what we see in mechanisms such as what we see in the informal or people settlement, so people try to resolve cases by negotiating. So all that together is called traditional. And because it's all called traditional, we cannot use traditional in the classical anthropological sense. That is why I adopt alternative justice systems. In terms of definition, alternative justice systems is both a philosophy and a practice. Philosophy because it dictates a particular choice, a particular method, a particular way of building our country. If you go back to the idea of diversity that we mentioned, and also to the idea of promoting human dignity in a way that does not talk about dignity as being one particular kind of universal person, but dignity that appreciates diversity that constitutes our country. It is practiced because the judiciary and everybody else is trying to catch up with what people have been doing. So it's a practice and it's a concept. And it's based on the constitutional framework, and most importantly on human rights framework and concepts such as the idea of freedom, the idea of equality, non-discrimination, dignity, and equity. The second concept that was defined in our work as part of our finding is justice. And we saw justice in two ways. Justice is both an outcome and justice is a process. As an outcome, the outcome of justice is what Commissioner Jadida raised, how human dignity is preserved, realized, and perpetuated. As a process, how people navigate and are treated in the relationships and transactions. So those relationships and transactions, the way people are treated therein, constitute an important component of the whole project of justice. So justice as an outcome and a process. What is a community? That's another thing that came in our findings. And again here, we see community as defined in Article 60 of the Constitution, which is not only based on language, religion, or culture, but also based on ecology, history, social, economic, and political category. For example, poor people can be a community. A gated team can be a community. People who share particular economic venture, like people who are fishing folk can be a community, a corporate society can be a community. And that is the idea of in the Constitution. Another finding was a distinction between AJS and ADR, ADR standing for Alternative Dispute Resolution. And we think that ADR is more legalese, is a legal mode of reasoning, which also takes dispute as a priori nature of life. AJS, on the other side, takes justice as the priori nature of life and is based on everyday idea of justice. So the distinction is very important here to remember. ADR is based on legal reasoning and takes disputes as a priori nature of life. AJS, on the other side, is based on everyday idea of justice and takes justice as a priori nature of life. But the two of them are not in conflict. In fact, ADR is a subset of AJS. The other finding that the task force established was the distinction between customary law and AJS. Customary law is established within the framework of multiculturalism, which is about maintaining differences. AJS, on the other side, is established and developed in the mode of pluralism. And that is about uniting people rather than dividing them, and is about forging the various elements of diversity to create a commonwealth, a commonwealth. And this is not just about tolerance. This is about really mingled coexistence. I've always said, look at the example of fruit salad and fruit cuts. Fruit cuts are various fruits in various distinct components, but fruit salad, you mingle it all together. AJS mingles it all together, as we shall see in the various topologies that we have. So two important frameworks, especially for you as a civil society now, is how is AJS manifested in Kenya? One, we have AJS manifested in a way that is around the courts, where we have, for example, traditional regulated courts in Kenya. This is not in existence, but we have the customary law as part of our common law tradition. So customary law, the way it is established now, basically is based on ideas of tradition and informality as envisaged in Article 159(2)(c). But in other places like South Africa, they have gone further to establish special traditional courts. Uganda has also done that. Then we have special tribunals. That's also a space that uses the ideas and the framing, such as the one that we have in AJS. Then you have formal AJS and ADR forums, such as family group conferencing, the small claims court that was recently established under the Small Claim Courts Act is also a form of an AJS-based court system. So there are AJS mechanisms that are established within the orbit of the formal courts the way they are now. But there are also others that are established outside the structure of the courts. And this is where we would like to encourage all of you to invest more as members of civil society. This is very important, particularly for this group. Here, we have traditional forums such as Council of Elders, and I'm happy I saw JK members have joined us. Rites of passage, ad hoc councils. Now you have had discussions going on in Bungoma about the initiation process either going on or not. That's an AJS conversation. We also have here traditional ethnic courts, such as the ones that we have among the Mijikenda, the Kaya elders, we have the Kaya king, and there are various Kaya courts. Then you have also popular forums, such as street committees. Street committees, I mean, if you go to Toy Market in Nairobi, for example, there are people who resolve disputes there between, between the main Ngong Road and the market itself, those who are on the market side. But if you go to the market itself, there are also market committees. If you go to road construction sites that are so many these days, there are committees that handle grievances. These are forms of AJS, which you call popular forums. Then you have NGOs, AJS, ADR forums. Kituo cha Sheria, which is represented in this forum, has been doing this for years. Kelin, which is also been doing this for years. LRF has been doing this for years. FIDA has been doing this for years. Pamoja Trust has been doing this for years as well. NGOs using the alternative justice systems. And so therefore our findings will be very useful for you to take on board. What are the findings? What are the typologies? Although when we were being established, the Honorable Chief Justice had thought we'll talk about one model. In our work, we have realized that to promote AJS, we need to think as broadly as possible. And therefore, we encountered 4 models. The first model was what is called autonomous AJS institutions. These are institutions mainly of council of elders, such as in Kuria you have Ebrasa, in Kikuyu you have Njama Yaigoti, in Embu also you have Njama Yaigoti, but I know the pronunciation is different. You have also a similar Njama in Kamba. Traditional systems that have been there for years keep changing with time, however, but autonomous, they're doing their own thing, they're free, nobody controls them. Then you have autonomous third-party institutions. This is where a third party, such as an NGO like LRF or Kituo Sheria or ICJ, talks to an autonomous group and works with them to engage. We've seen that done very, very well by FIDA in Kisumu, where they work with the Luo Council of Elders in resolving disputes. Kelin has been doing that. The Kenya National Commission on Human Rights worked with Njurinjeke for many years in resolving land disputes. So where a third party takes an autonomous group and works with them, that is called autonomous third party AJS institution. That is category number 2. Category number 3 is what is called the court annexed AJS institutions. Here is where we have a team mainly annexed around court user committees, which resolve matters and is dialogue between them and the courts. So they can take matters to courts, court can bring matters to them, then they take recommendations to court. Often this also involves probation department, and I'm sure Madam Chair is going to help us see a case study of this as we go on. And the last one is what is called the regulated AJS institutions. This is the one that I refer to as the traditional courts. We have this in Botswana, South Sudan, South Africa. There's a component of it here in Uganda. This is a replica, very closely a replica of the African native courts and the land tribunals of the 1980s. We as a task force have said this is not the way to go, because the Constitution in establishing AJS as a mode of accessing justice was about expanding freedom of the citizens to be able to design and to be able to be part of their governance. And therefore, if you have a traditional court incorporated, regulated by law, hemmed into the judiciary, you will have lost the meaning of Article 159 2C. Finally, I'm glad that my colleague Jadida talked about the framework of action. We as a task force have suggested that for you to deliver those modules, the framework of action is a human rights framework. And she's already taken you through the framework that we suggested of promote, respect, transform. Now, if you look at the Constitution, Article 159(2)(c), it basically says the judiciary shall promote. And we think that the way to promote is through these 3 action points, which is protect, respect, transform. And I want to give you a working example. So you have the actors, you have judiciary here, you have stakeholders, and you have AJS mechanisms. The pillars of action is protect, respect, transform. Allow me to explain a little bit more on this transform, because I think Madam Jadida spent a lot of good time on explaining respect and protect. Transform is very important because it means for us to realize AJS, the AJS mechanisms must transform themselves, and Article 159(3) ABC of the Constitution has given qualifiers. So the AJS mechanism must transform themselves to be in compliance with Article 159(3) ABC. At the same time, the judiciary must transform itself. They must embrace a new jurisprudence. And we have suggested ways through which that can happen. The judiciary must, for example, make sure that they take forward action to remedy the gaps that the Ajs institutions do have at the moment. At the same time, the judiciary must implement in good faith the plan of advancing Ajs, not sitting back and saying, this is repugnant, this can work. No, no, no. It's about them playing a more positive rather than a negative role as is envisaged in customary law. In terms of action, we think that transformation is about expanding civic autonomy, it's about promoting dignity, it's about expanding diversity, and it's about promoting dialogue. Those are the issues that we have put forward as a response to the key questions. The models that we suggest can be used to practically implement Ajs in the country, and also an outline of how the framework of respect, protect, transform works. Thank you very much for listening to me. Back to you, Madam Chair of the session.
Right. Thank you very much, Dr. Akoth, for that wonderful presentation. I'm sure participants were learning something, and we're beginning to see the content of the policy. To those who are asking whether the policy will be shared, you're beginning to already see what is contained in the policy. We note your questions and your comments that are coming in. We really appreciate your joining us from far and wide in this country, and we appreciate, continue to keep those questions coming. We're responding to them as a panelist as we move on, and those that we will not respond to in the chat, we will pick them and discuss them in the session later on. But Dr. Steve has mentioned something about part of the work that we did as a task force was to go to the ground to observe some of this, and we even pioneered some of the forums, and one such is the ODAIA, and therefore join me in listening in to the experiences from the ODAIA forum. Next, thank you.
Ajs, that is an abbreviation for Alternative Justice System. So it is a program that is in our courts where we work with the local administration. Those are chiefs and assistant chiefs, and we have elders who are citizens who serve in panels. They actually operate outside the court, where they have their meetings and negotiate and agree or disagree, and then after that, the parties will come back on an appointed date. The court will give the parties a mentioned date. They will still appear before us. The probation officer will address the court, and if they have an agreement, it will be in writing. We have been operating out there in our own models, so to speak. Whatever works for there is what we've been picking up and rolling it out and, you know, running with it all these years. But then, I mean, it gives us a lot of confidence in the work that we do if it's recognized in a policy. So that even as we sell this idea out there to the public, it is something that is entrenched in a document, that the judiciary has finally embraced this thing, and that gives us a lot of confidence and hope, even for the elders. Because you know, you cannot strictly want to control how these systems operate, but it's good to have it formally recognized in a document. But generally, I think it's a good document. If the elders are consistently supported with trainings, that would really help, especially because the law is always dynamic. There are always new things coming in here and there, and that is something that they actually ride on it. Like now, what they earn from this, from the program is consistent trainings. Ajs renders restorative justice. They're able to address underlying issues, and therefore, in my view, it reduces recidivism. It also reduces the workload that we have in court. There are so many cases that do not need our judicial time. I'd rather we spend our time doing those felonies, those serious cases, but these small cases, let them be handled out there by the elders. Let them be able to address the underlying issues between the parties, because I strongly believe sometimes we just, as the court, we scratch on the surface We are very mechanical in what we are doing, and we do not help parties to resolve their issues for posterity.
What a wonderful testimony from the Othaya Law Courts, just showing us that the work between the courts and the elders is actually complementary, and it is possible for the work of the elders to be recognized by the courts, which goes into the presentation that we just had from Dr. Akoth, and linking it quite nicely with the presentation we're about to hear from my colleague in studio, Tim Wishigi. Tim is going to just give us a brief presentation about the models of AJS and the interlinkage with the judiciary. So welcome very much, Tim.
Thank you very much. So what we're going to see is how the judiciary and the different AJS systems get to interact. Number one, if you look at what we have picked from Othaya, we have a different sort of an interaction with the courts, the probation officer being the secretary. We have other areas where the courts sort of have a different set of people interacting with the judiciary. Now, if you look at the duty of the judiciary, number one, the Constitution imposes a positive duty. So the judiciary has to promote alternative justice systems. So what we have done is to develop some of the minimum standards for adherence to the Constitution and the law for AJS actors. Number one, if you look at the Constitution, talks about fair hearing, procedural propriety, public interest, and the best interest of minors in cases where there are minors involved, what we see in Article 53. Now, we found some of the ways in which, in our learning interactions, and key among this is that the Bill of Rights has to be protected, respected, and fulfilled. The other key important provision of the Constitution is Article 10, where we look at the national values and principles of governance. Lastly, Dr. Steve has already made a point on this, the promotion, protection, and the transformative work within AJS. And lastly, that we have to what we call a test of rationality, or application of the reasonable and justifiable standard test contextually. In a nutshell, one, we have the protection of the fundamental rights and freedoms. Number two, protecting, respecting. So basically what I've taken you through. So these are the standards that in our learning we came across. To begin with, the courts may, for example, say a court avoids the whole idea of AJS, imagines that nothing happened in AJS, but then this would be contrary to the Constitution at Article 159, which requires courts to promote AJS. The second standard of interaction is monism, where awards from AJS are appealed to the courts, and the courts then have a review of both facts and the law. Now, the courts would again go looking into whether the case was conducted in a procedural manner, whether the decisions are proportional to the issue at hand, and then the court doesn't really interfere with the autonomy of the parties. The third one is that the courts review AJS cases for procedural propriety. So they just look through, was this trial conducted fairly? Was it open in the public? And was the decision arrived at proportional to the issues at hand? The fourth is where the courts go to AJS or refer matters to AJS because the parties have agreed to do so. Now, part of the challenge is that this method would sort of fetter the court in terms of promoting AJS, because AJS is a dispute resolution forum, just like the courts. The fifth is that the courts recognize and enforce the decisions of AJS the same way the courts do in arbitration. So in this case, the court does not go through the entire decision or the entire proceedings, but what it does is, if it disagrees with how the case was handled, it sends back the matter back to AJS, and in this case, then it requires that procedure must be followed, and that the decision must be proportionate. And lastly, we have what we call facilitative interaction. So AJS awards and processes are taken as providing evidence. So in this case, the court first receives the reports, then confirms that they are okay, and then proceeds to confirm the decisions. What then we find is that there are some of the modes of interaction that are not, the Constitution doesn't allow them, but there are others that the Constitution does allow. One is the courts, so in terms of the modes that are compatible, the courts, in deference, the courts review cases for procedural propriety and proportionality and approve those decisions. Second, that the courts recognize and enforce those decisions, like in the arbitral awards. The third way, the court then facilitates an interaction. So AJS awards and processes are used to provide evidence, because as you could tell from the presentation in Othaya, there are certain issues that the court may not be able to deal with when you think about the future of the communities that the court gets to interact with, whether you're talking about urban areas or in the rural settings. Lastly, that the courts go to AJS when the parties agree. So in this case, we are saying that the courts have to really seek the convergence of the parties. Now, we have two modes that we think are not proper. One is monism, where awards are appealed, and then the court gets to review facts and law. So, because in this case, you might have, again, stretched the justice course a bit too long. And avoidance, we have already said that avoidance is not in line with the Constitution. So what I'll take you through next is the flowchart. The flowchart then looks at, so when matters come to court, how do they move on to AJS? And we have a flowchart for when matters are criminal and when you have civil matters before a particular court. So in criminal cases, I want to first of all mention that we are looking at parties as being the principals and the court as playing the role of an agent. The court, whether you have the magistrate or the judicial officer, and the prosecutors are playing the role of an agent. So what you have in criminal cases, if a matter comes and parties request to go to AJS, then the court allows them to go to AJS. Or the court may, on its own motion, ask the parties, do you wish to go to AJS, or do you wish that the court proceeds? Where the parties tell the court that did not wish to go to AJS, the matter proceeds to hearing in the normal practice. Where the parties then agree to go to AJS, the court identifies who is a victim and whether the victim is agreeable to AJS, and they go to the AJS forum. When now this matter is referred, we may have an opportunity to talk about what happens in some of the forms that we'll be sharing in the course of the interaction with the different institutions. Now then you have to ask yourself, What time do we do this? Do we go to AJS? There is an opportunity before plea is taken or after plea is taken. And there are instances where this may happen after conviction, but before sentencing. Where it is before plea, then the courts will defer plea taking. If it is after plea, then the courts will defer hearing or defer sentence and set a mentioned date. Now, where the AJS forum makes a recommendation or a decision has been reached, then the court will look at whether the decision made was procedural and it was proportional. And in this case, a criminal case is withdrawn under Section 87. A little for those who are conversant with the criminal procedure, Section 87A and 204 will be the applicable provisions. And if there is no solution, then the court will proceed to plea taking and proceed for hearing. If we have a solution, then the matter is withdrawn again. If there is no solution, hearing continues. The same case applies if AJS is chosen before sentence is pronounced. Now, in civil matters, we still have a similar flow where parties request to go to AJS, or court on its own motion again requests the parties to consider AJS. Where the parties do not consider AJS, then the matter proceeds to hearing in the normal way where civil matters are dispensed by the courts. Where the parties agree to go to AJS, then consent of the parties is recorded. Then the matter is taken to or referred to AJS. A date for getting a recommendation is set. The court checks for procedural fairness, and a decision is arrived at. In this case, in civil matters, we call it a consent, is recorded, and the case is closed. Where there is no solution from the AJS forum, then the matter proceeds to a hearing in the normal sense. So that is in a nutshell how we envision the flow of both criminal cases and civil cases. Back to you, moderator.
Thank you. Thank you so much, team. And thank you to our participants who have continued to join us and be very active on our question and answer, and even in our chat section. We recognize you, and we will come to that very important session of the question and answer. But I'd also like to appreciate our panelists who are continuing to answer you, even as you write your questions. So keep it up, panelists. If you have just joined us, what we have been doing is taking us through the journey that it has taken the task force to come up with the policy that, as we said, is going to be launched on the 27th of August, and our chief guest will be the Chief Justice. We have invited all of you to join us for the launch. We will give you information as we near the date. And so what we have said in terms of the journey we have talked about today, Commissioner Jedida went first and she gave us the introduction, who we are as a task force. What was the mandate of the task force? What are the questions that we went onto the field? So sort of like a research journey. What are the questions we went with on the ground? And we have seen a video from Odaya just to illustrate one of the areas where we went and we studied to even see the complementary role between the courts and the elders. We had Dr. Steve, who then gave us a summary of the findings. So once we did the research, once we asked the questions, once we sat at these different models, what did we then find out? And he gave us, various models and how those models then were able to show themselves. And he gave us quite the information about how those different models were able to interact and how we studied AJS through those different, whether they were autonomous, whether they were court annexed. And you will see from his presentation that he even went ahead to say that the task force did not just study the models here in Kenya, but went outside into the continent, into Botswana, into South Africa, to study this model so that we can come up with a policy that is all inclusive and that is the best policy for our AJS. Now, Timothy then took us through, then after we came up with the findings, so what is the recommendation? And most specifically, therefore, how does the judiciary then interact with AJS? And he took us through whether we are looking at it before plea, whether if we're looking at it from a criminal perspective, whether it is before plea, before sentencing, all the way, and what are the different options? What can the judiciary do? And I'm saying this because we see in the question section that some of you have been very eager to know how the judiciary, but also how ourselves as civil society, we should interact with this. So keep the questions coming and we will address them. Allow me, ladies and gentlemen, to quickly move to our final panelist, who is Gertrude Ngote of UNDP. UNDP have done quite an extensive work and have experience supporting communities in ensuring active participation in the design, in the execution, and in the implementation of pro-poor policies and legislation. So Gertrude Ngote is here with us to give us the UNDP experience. Karibu sana Gertrude, and take us through. All right. Kindly proceed, if you can hear us. Would you like to unmute from your side? Go ahead, Gertrude, we can hear you. Just click on the slideshow on your screen and go ahead with the presentation.
What is wrong with Gertrude?
Gertrude, can you hear us? Right, before we get Gertrude on, perhaps we can begin with our question and answer session and answer just a few of the questions as we get Gertrude to tell us about the experiences of UNDP. We'll start with a question by Lorraine. Lorraine, thank you for your questions and your participation since the beginning. And perhaps I will allow Dr. Akoth to take this question. The question by Lorraine is, I recognize the fundamental and complementary role that both formal and informal justice mechanisms in facilitating access to justice. The judiciary, in consultation with ADR actors, concluded the development of the national ADR policy in December 2020. So her question is it safe to say that both the ADR and AJS national policies are aligned and complementary? And number two, is it possible to share the AJS policy ahead of the launch on 27th of August? Dr. Akoth.
Thank you, Madam Chair of the session. Well, yes, the AJS and ADR are complementary. In fact, if you look at Article 159(1), where after the Constitution declaring that judicial authority is derived from the people, it then goes ahead to delegate that. It delegates it to judiciary, and then after judiciary, it says, and this shall be exercised through tribunals traditional models, and so on. So from the reading of the Constitution, the answer is yes, they're complementary. However, it's important for us to read detailfully the logic of the Constitution there. The logic of the Constitution in both Article 159 and Article 1 is really emphasized on two things. One, how do we expand sovereignty of the citizens? That's why the Constitution starts by we the people. Now, expanding sovereignty of the citizens means that the role of the law has been changed from the initial role where the law was meant to be creating restrictions and creating non-do's, to the law being asked to create a framework of enabling. And that means that in the relationship between ADR and AJS, ADR, in my opinion, becomes a subset in AJS, in the sense that it's not a hierarchy, but there are two mingled frameworks, but one is broader than the other. AJS is broader than ADR, but the two of them are indeed complementary. In terms of sharing the policy before the launch, yes, that can be done, but you know very well that the policy is a document of the Chief Justice. We have collected views, we have drafted, and on 27th of this month, the whole policy will be made public. So let's just say that the policy will be made public on the 27th of August this year. And that day we'll make two versions public. We'll make the detailed version and a popular version public. Thank you very much. Back to you, Madam Chair.
Go on.
Thank you. Thank you. Thank you very much, Dr. Steve. I think that question has been answered. Let us know, Lorraine, if the question has been answered satisfactorily. I also see from the chat section a lot of you asking for the presentations from the panelists. Kindly write to us at the task force. Our Gmail address is ajstaskforce, one word, at gmail.com. That is ajstaskforce@gmail.com. Write to us and we will then send to you the presentations that you require. All right. Gertrude, I don't know if we have you back, if you can hear me. Gertrude? Right. Gertrude was going to give us perspectives from UNDP and their experiences, so just to show us, you know, the experiences that we've had as civil society organizations on the ground. So as we try and get her back, if we will, allow me to bring in Eric. I don't know if Eric, you're with us. Eric is from the Legal Resources Foundation. The Legal Resources Foundation has also been interacting with AJS, and Eric is here to give us a few perspectives from LRF. Eric, can you hear us?
Yes, I can.
Fantastic. Kindly go ahead.
First of all, let me say thank you so much for every other speaker who has spoken and for the moderator for giving us this opportunity. Nonetheless, I would like to begin by asking a question. When I married COVID-19 and listening to Commissioner Jedida and listening to Justice Itatis and Dr. Akoth, then I'm asking, is it possible that we can decenter AJS from the rituals of the mainstream justice system? The reason for that is that civil society required to participate, and their participation is anchored on how free does the AJS run away from the formalities of the mainstream justice system. And I may not want to belabor to repeat what others have said in terms of where do we find, where is this anchored? When I read the Constitution at Article 10, and most of you have made reference to it, at Article 11, and I would like to talk about Article 11 because it says cumulative civilization. And therefore, in our cumulative civilization, we realize that the formal has worked, but not to a good extent, that gives us the autonomy, that gives us the freedom to ensure that all of us then arrive at what is justice. And then that goes all the way to Article 48, 27, and all that, up to Article 159. Now, our experience is this. What is the legitimacy? Legitimacy of the decisions that are made. And the decisions that are made within the formal system could be legal. We may not be so sure if they're legitimate in the eyes of the community. And therefore, legitimacy under the Ajs system is not only broad, it is more acceptable. And most of those decisions are actually binding. So when we box the informality into the formality of the mainstream system, then I think we make a mistake. Something else I think we have learned is this. We do not learn from community perspectives. Rather, we confiscate them. And the mainstream system requires to borrow from the informal system or the Ajs system in a way that it builds it, not taking away the power and the knowledge that those systems then hold for the beneficiaries that they serve. And this has been learned from various platforms. We have the Isiolo platform, which is quite interesting, that it was first a community initiative, and the court then tapped in. And I think Timothy has explained this in a way. But nonetheless, what the Isiolo aspect has done, it has even invited women. One of the misgivings that people had heard about Council of Elders is that women are not part of that definition. But Isiolo has proved otherwise. Number two of that Isiolo provides very interesting dynamics. We even have an interfaith network that then deals with matters that have religious connotations that sometimes our formal justice system may not be able to address. And the other aspect is that it has even an intercommunity besides the Council of Elders that are more ethnic in composition. If you go to Kericho, where LRF has done considerable good work, you realize that the ideal small claims court should be what the Kericho Ajs system has been doing. That the small claims court requires us to remove the rituals, the technicalities of the mainstream system. And therefore, it is a good place to borrow for what those guys have actually done. Something else is looking at the Turkana experience. And the Turkana experience tells you this, that Ajs responds to the uniqueness of the challenges that people are faced with. Look at the court system in Lodwar, in Turkana, is only at Lodwar and maybe Lokichar, and sometimes a mobile court if funds are available. So the Ajs system then addresses those inadequacies, the distances that people are supposed to travel to ensure that they access justice. Having given that background, what do I think, or what does LRF think that civil society can plug in? How do they plug in? Number one is, can we invest in capacity enhancement of the Ajs systems and not confiscate them? Let us enhance their capacities. And that means look at how the Council of Elders is operating and give them more knowledge, considering that some of the things they do, they actually borrow from their decisions are a confluence of laws. They apply customary law, they apply conventional law. And sometimes they look at practices that have worked for them over a long period of time. That is rich, that is wealth that we may not want to lose. Number two is the sociology of offenses. How do we help communities understand sociologies of the wrongs that we claim they have done? The court is likely going to deal with the act. It may not deal with the relationships that come after thereafter. The relationships that are likely to be frozen. You can only deal with that if you understand the sociology of the wrongdoings that are being claimed. And therefore, as civil society, that is a space we could easily occupy. Number three, are we able to build community agency? Let us build sustainable community structures that then enrich what they have rather than take away what they have and box them into the formal system. It is therefore important to look at justice in the lessons of the community. Because sometimes we punish wrongdoers twice. We take them to court, they are punished, they go back home, they are punished. So there is need to look at how then does AJS speak to the formal system, and how do we, for lack of a better word, sanitize those decisions that then some of these offenders are not punished. Something else is do trainings, develop tools that can then become reference documents for this work going forward. And if we say that, then we'll be saying that the AJS is not a mistake, because reading the law in the spirit of releasing AJS, then when you look at Article 10, it talks about inclusivity, it talks about social justice, it talks about equity, and you look at Article 159.2.3, then you are saying it is high time civil society plays the role of decentering AJS from the mainstream. And the purpose of doing that is to make civil society not become brokers of justice, but facilitators of justice. Thank you so much.
Thank you. Thank you very much, Eric. Civil society to not become brokers, but facilitators of access to justice, indeed. Thank you for sharing your perspectives from Isiolo and from Turkana. We are now joined by Gertrude. Can you hear us now, Gertrude? Gertrude, can you hear us?
Hello, good afternoon, colleagues. Can you hear me?
Yes, we can hear you, Gertrude.
All right. Much apologies to begin with for the hitch in technology. First of all, just to say good afternoon and to thank you very much, the Alternative Justice System Task Force of the Judiciary, for inviting us, and also very importantly for the hard work and the tenacity towards getting us to this journey of the AJS policy, a much needed facility for civil society organizations. Let me begin. Sorry, I am the computer projecting is different from the one presenting, so sorry for that. Let me just begin by, looking at the role of civil society organization in implementing alternative justice system. What are the key things in what we have been requested to speak about is the role that we have, the role that civil society has in this area with regard to the areas of practice in relation to research and outreach. And to begin with, I think it's important to note that a fundamental analysis of engagement of civil society organization in alternative justice in Kenya is very timely and very useful, as can be seen from colleagues through the chat box and colleagues who have spoken, the task force members and the vice chair. And when to begin, we can look at what Justice Dunstan Mlambo in one of the presentations in 2014 in South Africa said, and of course, I'll be inviting civil society colleagues to place themselves in here. Let me just read through that quote, which is that access to justice rests on two premises, primary and secondary. Primary access to justice will occur at the grassroots. It is the very entry level, the first stage where a person interfaces with the justice system. It accounts for the largest number of interactions between service providers and those who require those services. You will remember the poor, the marginalized, the persons with disabilities. primary access to justice largely revolves around legal information sharing. This is what the judge says. It is not just about legal assistance. However, empowerment is at its core. And all the speakers here have talked about empowerment, training, including Eric, who just talked about empowering the community leaders. Most people who approach the community advice offices in South Africa, which is synonymous to the AJS here, have no interest in going to court and litigate. And the judge says, to me, the primary level is a very important stage. It determines what happens to a person next. However, we always recognize the second. I just thought to put that in perspective in the very beginning. Let's proceed. So who are we, and why are we able to say something about the role of civil society organizations in alternative justice system? We are Amkeni wa Kenya, which is a UNDP Kenya flagship civil society facility, and it focuses on access to justice, human rights promotion, strengthening the justice systems like the alternative justice. And we are interested in seeing that people are able to see, people are able to feel just, equitable, affordable, accessible, sustainable, credible, accountable, formal, and alternative justice system. And already the partners we are working with, which are the civil society organizations, have already begun to put in place and engage with strategies that would be very useful for this policy. Building the capacity skills. For example, one of our civil society organizations has already established a grassroots community referral pathway where they're linking the national level human rights institutions and duty bearers. They are developing standard operating procedures for alternative justice. And I could hear Dr. Uma properly say, AJS would encompass all the other modes of alternative dispute resolution. A harmonized approach. They're coming up with a harmonized approach and a manual to sensitize these mechanisms. Local council of elders. Somewhere in the Rift Valley, there is a community of elders called the Kipgam members, being supported by one of our civil society partners. And they're undertaking mediation techniques, referral mechanisms for dispute, and ensuring that they are gender responsive and they are taking on board human rights-based approaches. Strengthening community justice systems and alternative dispute resolution to respond to key populations. Some of these persons who will depend on us as civil society to ensure that they receive justice or they are able to have their dispute resolved, we really need us to be their agency. And one of our partners is undertaking work with men having sex with men and sex workers somewhere in the western part of Kenya. And they are already engaging alternative justice system mechanisms. And due to the very nature of this key population that I have just mentioned, they prefer either alternative dispute resolution or an out-of-court settlement. So which builds very heavily on what we are speaking about and this very key policy. Many civil society organizations have also proposed to train and operationalize the alternative justice system and to even disseminate, to the alternative justice system committees and to disseminate the policy. So overall, let's go to the next slide, please. Overall, for civil societies, we see that this policy provides a breath of air into the articles of the Constitution, as the speakers have spoken here before. And of course, which is foundational to our engagement and the engagement of civil society. It also offers the models which were taken through by Dr. Uma here on alternative justice system. But more importantly for civil society, we are looking at the autonomous third party, which almost gives us an opportunity to be significant drivers or actors in alternative justice. We need to learn, we need to engage, we need to create awareness in order to effectively complement the judiciary. There will be rules, there will be guidelines, and therefore using this, we should be able to effect the Ajs policy and to have it have a meaning in the lives of the people we serve. And then, of course, what do we see about this policy? It also offers, to a very large extent, a functional perspective to civil society organizations, because you all, and we have all known that civil society organizations have initiatives that are either undertaken as out of court settlement or alternative dispute resolution mechanisms. But this policy emphasizes the extent to which they have a functional duty and not just merely a descriptive account of the interventions that you have always done as a civil society organization. Next slide, please. Yes, and what again does it do? The policy affords civil society organizations an opportunity to canvass and promote matters spanning across advocacy, litigation, social media, research, etc. It affords paralegals, and very important because we are also in an era where the Legal Aid Act has recognized and put a place of paralegals in the law. But this policy even enforces that further. And paralegals are very key for the grassroots. It specifically provides community-based paralegals, for example, an opportunity to bridge the gap between the poor, vulnerable groups in rural areas, but also we are looking at what it is that they can do, provide education to larger groups of people. And it establishes justice advisory centers for dispute resolution. Again, an opportunity for civil society organizations to engage. Well, that's taking a bit of time. Yes, it addresses massive gaps in in access to justice in our country. And also this policy is important. And why is it? Because be it church leaders, be it chamas in our country, civil society organizations, community-based organizations, then they have an opportunity. But also, it doesn't exclusively leave the work of filling the justice gaps to lawyers. It gives it to the ground, which is very focal when you remember what we spoke about earlier, Justice Dunstan Mulambo's talk. Yes, so in response to what we were asked to speak about, which is the role of civil society, and we are going to be looking in three areas very quickly, which is based on your areas of practice, based on research, and also based on outreach. What is it that civil society organizations are able to do in implementing the alternative justice system policy? So when we look at in relation to the areas of practice, when we look to the areas of practice, then one of the things is that civil society organizations ordinarily advance justice on a daily basis. They train, they recruit paralegals, they use cohesive champions, youth champions, opinion leaders to provide this. But with this policy, civil society organizations will play a big role and support to arbiters, to alternative justice system practitioners, and of course, looking at the mainstream officials there in ensuring they are able to train them, be involved in the recruitment process. Secondly, it is that civil society organizations are here to provide a very crucial link to justice services and legal redress. Ordinarily, again, this is done, but with this policy, they will need to step up in as a first port of call. You remember we said that it is the first place that the communities will run to, where legal assistance especially will be unavailable. Again, this provides an opportunity. They will need to use knowledge of law, government agencies, tools like mediation and negotiation, etc., to advocate and to offer concrete, holistic, long-lasting solutions to communities that are in conflict and to issues of justice that require their representation. They will also use this policy or engage with this policy to navigate multiple legal systems. It is civil societies who will know the existing customary legal codes and religious codes in our countries across the country, and therefore will be able to engage with this. Link with advocates and lawyers to provide guidance and or resort to litigation. So this would be essentially, basically a brief on what civil society organizations will do in regard to their areas of practice. Next, please. So before we leave that areas of practice, I just thought that we need to remember the shared challenges that will come with that opportunity. And it is very likely that we may face the twin problem of insufficient funding and inadequate training. So what will be the CSO's role, either at county level, nationally, or even internationally? There is challenges that may come with relation to the skepticism within the legal profession. What is the value addition of alternative justice system? The civil society organizations will have a role. They will need to establish mutually beneficial collaborations with the alternative justice systems. The different models of alternative justice system that we have been presented here, and of course upon the launch. The legal profession and key governance justice sector is very critical. So constant engagement by CSOs will be key to unlock that kind of a challenge. Then the sustainability, which Commissioner Jedida spoke about, it will be dependent on appropriate investment by government, private sector, and donors. But again, who will do this? It will be civil society organizations, because then you will design projects, programs that will enable us to implement the policy even together with the partners. Next slide, please. Sorry, it's taking a bit of time to go on. So secondly is, of course, to look at the role in relation to outreach work. We were looking at areas of practice. In relation to outreach work, what will you do? You will raise awareness. Target groups, public constituents on Ajs policy, distribute books, research, products to vast communities. That would help in terms of outreach. Articulate specific interests for the poor, for the marginalized, for the minorities, for the women, for the youth, relevant issues of interest. Create communication channels, for example, public debate, to enable participation and support for the Ajs to be able to effectively be implemented. Empower the youth, persons with disabilities, and other minorities and marginalized groups to be able to promote and use these alternative justice systems. Forge partnerships with government institutions. Facilitate intermediary, which is, of course, provided for in our constitution, and there are rules around it in the Office of the Director of Public Prosecutions. It would be very critical for civil society to facilitate the intermediary in alternative justice, in courts, in police station, and establish very good relationships in that regard. Advocacy, facilitate interaction between communities, individuals, and alternative justice systems to be able to build a participatory, but also responsive, accountable, and transparent Ajs systems, ensuring that the concerns, particularly those that come from the poor and marginalized communities, are able to be taken on board. Next slide. And of course, you will undertake all other usual activities that you have always undertaken. And very lastly, on answering that question on the role, will be to look at the area of research. What would be the role in this regard of civil society organization? We see this to be already a lot of the work that is being done by civil society organizations up and down the country, but a research repository. And one of the ways would be to have an Ajs community level publishing. These will be very critical to enhance exchange of information within and outside various communities. Like we said, what is practiced in the western part of Kenya may not be what is the same that is practiced in the northern. So what would be the learning there? So identify the common themes around that, be able to undertake necessary research that would also be very helpful in sustaining the Ajs mechanisms that we'll be engaging in. Knowledge systems and material resources from Ajs community will be expected to be helpful in identifying areas of great concern, but also build it into books, publications of books that can be used to discuss and come up with practical solutions on different issues, information, and also case reporting templates, documenting customary jurisprudence, like it has been spoken to by various speakers here, will also be part of the work that civil society will be helpful in engaging with. Ensuring that there is learning exchange, two-way communication between the civil society, community-based society organizations, chamas, whichever it may be, will be very critical, a two-way communication to be able to enhance information and generation of material that will be useful and replicated as such. Next slide, please. I'm almost concluding. Yes, so just key things to remember would be as we go into a civil society engaging with the alternative justice system policy, it would be important to remember to start from the beneficiary perspective. We speak about the poor, the marginalized, the minority, the persons with disabilities, but how well will we be able to augment their perspective in the whole of this process? In-depth understanding of the AJS policy, when it is finally launched, and we are glad to hear that there will be popular versions. As civil society, it will be critical to go in ourselves and be able to understand the policy and the areas that are very critical to enable our engagement. Adopt a rights-based approach. I think this applies across, and we are aware of this. Give priority to the poor, and I've already mentioned that, to ensure that there is no one left behind, because this is really what it is meant to achieve, that nobody is indeed left behind. And then, of course, recognize the three models, but that will also be informed by our in-depth learning and understanding of the policy. What is the nexus of this policy with the Legal Aid Act? And of course, the task force members have also brought in other laws critical, like Small Claims Court Act and all that. How will we bridge? How will this nexus between the AJS policy, the Legal Aid Act, the Small Claims Court Act, and all other pro-poor policies be very helpful to help us to bridge the gap and the impediments in access to justice, the cost, the cost of justice, the accessibility. We all know all that, the languages of the law, because there's simplicity around this policy. How will this nexus be very helpful to help us? Using paralegals, for example. And of course, a few questions that are coming from our civil society organizations. I'm sure you will go into that area. We will be going into that area. But just for the task force, maybe you may need to underscore more on the structure composition of these AJS systems to ensure gender balance. Of course, Commissioner Jedida spoke about this and other presenters, including Timothy, but civil society organizations seem to be saying they would need to have a bit of an understanding, more understanding on this, our partners, our implementing partners. Then there is the enforceability of the decisions, particularly from third party and autonomous models of alternative justice system, and therefore contribution to jurisprudence. We all know that we come from a litigious background, and not necessarily that it will be a big issue, but our communities are such that they would only consider a matter to have a legal effect or jurisprudential effect once it has been formalized in a way. How are we going to be able to navigate? These are the questions that are coming from some of our implementing partners. And very finally is the financial sustainability question, which of course we have given some of the text in, what is the research that will inform this and help in order to be able to build and of course effectively implement this AJS policy. I thank you, colleagues, and sorry, it seems to have taken a little longer.
All right. Thank you very much, Gertrude, for quite an insightful presentation and, letting us know what are the various ways as civil society organizations that we can engage with the AJS policy towards its implementation, whether we do that in our capacity as research institutions, as academic institutions, as part of our work in community outreach, and whether we do that also in terms of the practice, the things that we do on a day-to-day. Thank you so much for that presentation. allow me, participants, to ask that we have some extra 10 to 15 minutes so that we can engage you. Seeing by the number of questions that have been asked, I have with me more than 50 questions from yourselves, which just shows how much you are interacting with us. So kindly indulge us for, an extra 10 or so minutes after the 2 hours that we had promised to finish, so that we can give us an opportunity to ask. So we request, I can see we have hands up. I will give you a minute. I will give you a chance to ask your questions in just a minute. Perhaps we can start with those. We have Caroline Hassoa. Caroline, can you hear me?
Yes.
1 minute for your question or comment.
Yes. Thank you very much. Thank you very much. My question goes on the role that the AJS can do to unlock legal aid access, the legal aid fund, even at the county levels. While justice is not a devolved function, but alternative justice is a devolved function. Is there anything that the task force can do to put in its policies and create awareness in the county assemblies to provide money for community, civil society organizations at the grassroots level? And how do we make this AJS resonate in the wards and have that mass effect to resolve people's problems at the grassroots level? Thank you.
Right, thank you very much, Caroline. We have Clement or Ketch. Can you hear us? Clement, can you hear us? Right, I think we go to Paul Masese. Paul Masese, can you hear us?
I can hear you.
Great, go ahead. 1 minute for your question or comment.
Well, thanks a lot. It has been such a great afternoon. I would wish any of the panelists to speak to the risks associated with AJS. I think yesterday and today we've not had any presentation on an analysis of risk and assumptions. So if anyone could speak to that, I would be home and dry.
Thank you. Thank you very much, Paul. And thank you for joining us even yesterday. And we welcome you to our future webinars. I will take maybe 2 more questions. We have Jennifer. Jennifer, can you hear us? Please go ahead. Jennifer?
Yes, I can hear you.
Yes, 1 minute for your question or comment.
I'd actually put it on chat, but I'll read it out just for the sake of getting it out clear. First, I'd like to thank you very much for the insightful forum. Now, if I understood Eric Mukoya correctly, he has made a valid argument for the case of divorcing the AJS system from the formal justice system. So this, in my view, is critical in safeguarding the very core and essence of AJS, because subjecting AJS to the formal justice system speaks against the fact that AJS has the capacity or ratification from the state-run justice system. I think that would be erroneous in the sense that we would be understanding the state as the only legitimate promoter and custodian of justice. So I kindly request Dr. Koth to explain the rationale behind the decision by the task force to link AJS to the mainstream justice system. Thank you very much.
Thank you. We thank you, Jennifer. I'll pick 1 more. Kiara. Kiara, if you can hear us. Kyra, sorry, apologies. Kyra, can you hear us? All right. Perhaps give Ali Adan. Ali, can you hear us?
I can hear you.
Great. 1 minute for your question and comments.
The first one is comment about this seems to be a good work.
Thank you.
And we appreciate the task force for taking this time and preparing such a noble work. The second thing is that this community-based justice system, let me put it that way, as simple as that, normally may not have the formal way that they are informal at the community level, but many formal systems are not aware they do exist. So I think the task force will also take a lot of time in the formal system so that they recognize the importance of this, because most of times the communities may have ability to solve so many issues at very short time, and they may not have backlog, they may have the background to such information, and sometimes they are a bit better when it comes to solution of complaints compared to the normal justice system. So I think there's need to link the formal system to this informal system, if I may put it that way.
All right. Thank you very much, Ali. So let me read out a few of the questions. I'll try and categorize them because there are so many, and we thank you for them. And I'd like to ask also the panelists to just go to your question and answer sections and continue to answer these questions. And we will continue to engage with you for sure, even after this session. So just trying to cluster the questions. We have Kimutai, who's asking about the sort of like the jurisdiction. So which types and natures of disputes can be handled by AJS? That question is also shared by Betty Okero, who's also asking, something to do with jurisdiction, but also standards and evidence required, especially in when you link AJS with the courts. So the worry or the question about whether the standard of evidence is the same as that is used in criminal cases. And that question is also shared by Elias. We also have another kind of question that then relates to children. And so how AJS interacts with cases of children and how it proposes to continue to interact with cases for children. There's a question for gender, and the persons asking about gender want to find out now that there are worries that AJS uses culture and such other laws or systems that are anti-women, in their opinion. They ask, how do we then ensure that AJS promotes equality going forward? The other questions are to deal with delinking. I think sharing in Jennifer's question earlier, delinking AJS with the formal justice system and just asking for a justification from the task force as to why we proposed to link AJS with the formal justice systems. A question from Zipporah asking about the monitoring and evaluation, whether we have an M&E framework to monitor and track the milestones through the implementation of the policy. Finally, a question to ask about the role of the DPP, and especially in relation to criminal cases, and whether the ODPP will have a role to play whether AJS systems can or cannot. So also going into the jurisdiction. So allow me to invite Dr. Akoth to be followed by Commissioner Jedida, and then we'll have Tim here going into those questions. So for you, Dr. Steve, you had the question on delinking AJS to the court system and what that justification is. So go right ahead.
Thank you very much. allow me to start by making an announcement. I just consulted with the chair of the task force, and we realized that the number of questions raised today and yesterday are so many. So what we have concluded is that on the day of the launch, which is Katiba Day, 27th of August, the launch will take 30 minutes. It will be an online launch, but we will start with a 2 hours session, which will solely be dealing with the questions. So we will come back to the questions of today and yesterday. And from the time the Honorable Chief Justice will guide us on the timing, but 2 hours after that, before that, we will be dealing with questions. On that day also, we'll give you access to our AJS TV, which will be rolling out from that day, and you can see who our anchors are, and you'll be able to, even without logging in, you'll be able to follow the streaming live on that day. So to repeat again, on 27th, we'll have 2 hours for questions and answers. So I just want to respond to two fundamental questions, one on the jurisdiction and the other one on the linking up to the courts, because all of them sort of are within the same logic. So now, let me start with one of linking to the courts. You see, the Constitution in Article 159 is very, very explicit. And that's sort of what ties us. It says, the judicial authority is derived from the people and vests in and shall be exercised by the courts and tribunals established by or under this Constitution. In exercising judicial authority, the courts and tribunals shall be guided by the following principles. It goes on and on. And then it comes back to one of them being traditional dispute resolution, which we call AJS. So this linking to the courts is not linked in the form of hierarchy. No, it is linked in the form of orbit. It's like the sun and the planets, that we are all circulating around an orbit. So we form an orbit. So that way we have dealt with the power question. If I would explicitly go to Betty's question, we've dealt with the power question. Initially, the relationship between the courts and AJS institutions, or customary institutions as they were called, were on a basis of hierarchy, where justice dispensed by customary institutions was seen to be of a lower threshold level than justice dispensed by the formal court, so to say. So that hierarchy is gone. The policy erases that hierarchy, or rather the policy reaffirms the Constitution's vision of erasing that hierarchy. But then for a mode of relationship, we form an orbit. So we circulate around the judiciary as a way of just creating order as done by the Constitution. So remember, judicial authority is derived from the people, but it's delegated. So that delegation framework is what creates the orbit. And that's why we have that link. But that does not mean that independent institutions like autonomous or even third-party autonomous get grafted into the judiciary. In fact, we are against formalization. We are totally against formalization. Second question is jurisdiction. The jurisdiction question is answered not by creating category of cases like civil, criminal, children, no. It's by creating a principle. And the principle is then used to clarify the jurisdiction. And the principle we've created is a principle that we call the agency theory. The agency theory is premised on two frameworks. One, freedom, that each actor going into an AJS institution or space goes there in their own volition, knowingly and able to decide. Now a child can't decide, so that automatically knocks out the children's cases. As an institution where gender rights or gender representation is not taken into account, then that means that that actor can't decide. That knocks it out. So this notion of freedom as a component of agency is very important. The second component is the ability to get in and get out. So the AJS institution, as part of respecting agency, must allow parties to be able to get in, get out at will. And you know, consent these days is not defined in the narrow sense of saying yes or no. Consent is also the ability, the power, back to you, Madam Betty, the power to say yes or no. So if parties are in a structural relationship where they have no power to say yes or no, AJS is knocked out. And third element of agency is about if it's a matter, for example, where the state offers the best possible reprieve and has the best instrument of reprieve. For example, matters of treason. You can't solve treason through AJS, for example. But you can resolve matters of violent extremism or terrorism through AJS. Somebody asked that, just to relate that. So this agency theory is very, very important and is a core criteria of determining what matters come to AJS or not. Thank you, Madam Chair. And remember that 27th August date is very important, and we expect them to bring in all people who have been part of the sessions then for this Q&A session. Thank you. Back to you, Chair.
Thank you. Thank you so much. Commissioner Jadida, in 2 minutes.
Wow, 2 minutes. I am a human rights practitioner and believer and defender. And therefore, anything that AJS will assume in terms of violating human rights principles, the rule of law, the constitutional order, is something that as an individual working with AJS would have to flag out. I think the beginning point for this whole conversation is that there are things we must unlearn because of our historical orientation. Our historical orientation is that AJS, particularly when you focus on traditional justice systems, they are negative infrastructures. They have no justice value, they have no economic value yet. Data tells us that 85% of us are using the AJS systems in one way or the other, either directly or indirectly. It therefore tells me that, and I want to link this with the question from Paul on the risk assumptions and Caroline. We have actually been talking about these things. One is that the risk that we continue to have is that language continues to be anti-AJS. For example, referring to AJS as alternative justice systems. They are really the appropriate justice systems in that respective community, be they cultural or otherwise. So what is appropriate for the Turkana people? What works for them? 90%. That is what we need to ask. So we have to develop the language that is affirmative to the AJS system. When we talk about formal and informal, we say one, actually the language we're having is that one is serious, the other one is less serious, one we can respect and work with, one we cannot. And we have to change that language that what is formal is what is in the courts. What is traditional or what is AJS is also very formal to those people, and not formal by virtue of a serious solution, but by the issue of that what is happening may not be constructed within the classical common law system for a process, but they have systems, they have processes, they have procedures, and they have standards that they use. And that is very important because once we begin developing the positive language of engagement with the AJS, we will begin seeing the beauty and the gem that is hidden in the AJS that all of us appreciate when the so-called form or the court system does not work for us. Now, other risks include the whole issue of gender and children. We have talked about it. But if we continue to build the capacity, as Angote has said, of these AJS actors, first of all, they need to know what does the Constitution say. That first and foremost, many of them did not know that AJS is respected by our Constitution. So that we stop playing the hide and seek process that continues to suffocate a very, very broad and important infrastructure. The other thing is about legal aid and access to justice. This is Caroline. The Legal Aid Act already foresees the AJS infrastructure in terms of providing a community-based system through the Justice Advisory Centers to provide alternative justice systems in terms of dispute resolution. What this means is that at the county level, we can take it as far as possible to ensure that justice is a function from the lowest point. And it doesn't need the consent of anyone because it's already functioning. What we need to ask ourselves, what infrastructure do we have within the county level that can support, especially in issues of education, and also in issues of promoting the delivery of justice at that lower level. The last thing I want to say about AJS and the AJS policy. This policy does not answer all the concerns and all the challenges that are there. But what it does is that for the first time in the history of the Republic of Kenya, the judiciary has taken the first step initiative to interrogate from a positive perspective what opportunities does AJS provide to complement the common law justice system as we know it in our courts. One of the threats that, and also a positive assumption, is that the judiciary, and we can see there's been positive progress, the legal fraternity, especially the landed friends, will embrace this and will not see it as a threat to their bread in the court. In fact, it reinforces their work and helps them deal with more serious issues that need the court system to deal with. Lastly, let me say that let us all remember that AJS systems do not only resolve disputes. They have a much broader function. That's why they have a restorative nature of justice system. And that is the way we need to understand them and appreciate, and then see how far can we work with each of the systems and mechanisms that are there. And then how do we need to infuse the constitutional and human rights instruments that needs to up and uplift the AJS system. Thank you very much, Teresa. I know that was more than 2 minutes.
Thank you, Commissioner, and to my co-studio host team.
I think I will respond to two questions very, very fast. One is the question of land problems. What we have in our plan is to organize a webinar that gets to speak to the land question. So we want to urge Owala to look out for it, and we will have your email address. If you could type your email address on the chat, then we will get in touch with you. The last one is the question of the post-launch implementation. We have a plan to ensure that there is a team that will ensure that civil society organizations get to know, to interact with the policy deeply and interact with the task force deeply, so that then we all move in the same direction. Thank you very much for participating, and thank you, the moderator. Asante for the chance. Okay.
Thank you very much, team. And thank you to the facilitators in today's session. We thank you very much for that. We'd like to say a special thank you to the Lawyers Hub, from where we have been going live from. And just to give them, a bit of appreciation, we'd like to have Selina call in and just tell us a little bit more about the Lawyers Hub, even as we move into conclusion. Selina, if you can hear us.
Hi everyone, yes, I can hear you. My name is Selina Onyando, and I am a Tech Policy Fellow at the Lawyers Hub Kenya. First, I would just like to say a huge thank you to our partners for making this session possible. I think these collaborations are key in driving the implementation of such systems. At the Hub, we're always looking for innovative approaches to justice, and we think alternative justice systems are essential, as they do not only decongest the courts, but most importantly, they ensure justice for all. And the work of the task force is very encouraging. For those of you who may not be familiar with the work that we do at the Hub, the media team will be airing something shortly. Thanks again to everyone for joining us, and we hope that you all had a fruitful session. Thanks.
Thank you very much, Selina, and we do thank you for the support and partnership that we have enjoyed from Lawyers Hub, including our webinar session yesterday. Allow me to thank the panelists today. Thank you very much, Dr. Steve Akoth, who is our Vice Chair. Thank you for your insights. Thank you, Commissioner Jadida, for your insights as well. Thank you very much, team. Allow me to also thank Gertrude Angote for your insights and your experiences from UNDP, as well as Eric from the Legal Resources Foundation. We would like to thank you, our participants, for coming in and asking your questions and interacting with us. And we do hope that you will continue to interact with us through the Gmail that we gave, ajstaskforce@gmail.com. We have been live from Lawyers Hub. And until next time, we have webinars that are coming in. Allow me to say that as we end, we have one webinar that will target social justice centers. We have one, as Tim was saying, on land, and we have one on youth. So keep your pulse on the ground, and we will reach out to you for these webinars. I conclude by saying Happy Eid ul-Azha to our brothers and sisters in the Muslim community. Over to you, Lawyers Hub.
The world is changing faster than ever before. In the past 10 years, there has been an exponential technological evolution, the kind of technology that has revolutionized the world of work as we know it.
The Lawyers Hub was founded on the principle that law needs to interact more with technology, and that greatly affects tech policy as well as access to justice. So the Lawyers Hub exists as a confluence between law and technology, working on tech policy, on emerging technologies, as well as increasing and upskilling the knowledge of lawyers in the area of technology. We support tech startups as well to ensure that the tech ecosystem also engages in policy, but as well understand issues around data protection, issues that also concern their structure, as well as intellectual property.
If you look at the evolution of technology, it's been relegated as an alternative in most systems. But the realization that 21st century has brought us into is that technology has to be an integral part of our day-to-day systems. And if you look at some critical technology areas like artificial intelligence, blockchain, nanotechnology, biotechnology, then it gives us a strong indication that if we do not start having discussions on the use of these technology areas, as far as law is concerned, then we may be in some kind of trouble. So Lawyers Hub is leading the debate on the use of these technologies, especially in Africa.
Over the years, the Lawyers Hub has supported the innovation ecosystem, convened events such as the Africa Law Tech Festival and the Global Legal Hackathon. The Lawyers Hub has also supported government innovations within the justice sector, as well as trained government institutions and more than 10,000 lawyers across Africa on emerging tech policy.
Our dream at the Lawyers Hub is to have open access to law. We envision a continent where there is access to justice through leveraging technology and with a crowd of enlightened lawyers. We see a continent that also protects its own through better tech policies, that emerging technologies, through its regulation, will offer better value and consumer protection for the people within Kenya and within the African continent. We envision that we will convene policy makers, regulators, as well as lawyers who are more enlightened on emerging technologies and with better digital skills. And we invite you to be a part of this great vision for Kenya and for Africa.